Number 85, J.P. Morgan Chase, National Association versus Caliguri. Counsel?
May it please the court, my name is Jeffrey Hertzberg, appearing on behalf of the appellant Boris Caliguri.
Sir, what information would, I'm sorry,
Excuse me, Judge Rivera, one second. Sir, would you like for me to reserve some rebuttal time for you?
Yes.
How much would you like?
3 minutes.
3? Fine. Judge?
Thank you. Sir, what information would be revealed by getting access to this original note?
Whether or not it was authentic and genuine, the original note.
Something you say could not be discerned from the copy of the note? Is that your point?
Absolutely not. To make sure that a note is original signature, the forensic document specialist, Jeffrey Lauper, needs to examine the original note.
Counsel, could you just clarify one thing along those lines? Are you only arguing the authenticity, or are you also disputing standing?
Both.
Both, okay.
Okay.
Thank you.
So I'm clear on the record, sir, up here. So I'm clear on the record. Has the original note ever been produced?
Absolutely not.
I see. So you only got an affidavit and a copy of the note?
A copy, an affidavit, and the affidavit says, according to custodial records, but it's not from the actual custodian, and there was never a document from forensic specialist affidavit that it was a genuine copy.
I see.
But your position, I'm sorry, up here, your position, you've never filed an affidavit on any of this, right? I mean, it seems to be your position is, I get the original note because I want to see it and I want to see that it's authentic, but there's no affirmation in opposition to this at all, is there?
As far as
Any facts? You've not put any facts in dispute.
it's important to realize that there was an original case that on the same
No,
note.
I understand that point, but in this case, you've not put in any affirmation in opposition to saying, that doesn't look like my signature.
No. No.
And doesn't the UCC presume authenticity unless you do that, unless you
No, it does-
specifically put it into issue?
We put in issue in the first case and also second case.
But
Right,
no,
but we're not
I-
here about that. We're here about this case.
But the first case, Judge Baisley specifically said that note had to be produced in discovery. At no time did they ever produce
Yeah,
it.
but this is a new case with a new index number years later. This is not law of the case. This is not that situation. And as I understand it, to the extent that you asked to have the case transferred back to Judge Baisley, that was denied and affirmed because under the so-called related case rule, at least how it used to operate in New York County, I don't know about Suffolk County, but once a case is gone and dismissed, any new case is no longer considered a related case.
Except
to
that
me,
the
that's
first-
just a request for forum shopping.
Absolutely not. The first case was dismissed on a motion for summary judgment, motion to compel. If you read the case of Collins v. Bertrand Yacht Corp., it says the grant of summary judgment, the procedural equivalent of a trial, results in final judgment on the merits, which bars another action between the same parties upon the same causes of action. In fact, Judge Rivera, in her affirmance, or concurrence, I should say, on the Paramount Pictures Corp. versus Alliance versus Transfer AG, specifically said, it is black letter law that a valid judgment bars future actions between the same parties on the same causes.
Can I just clarify again, and I'll circle back to something I asked at the beginning. So your position is that they may have a document that is a note, because they showed a copy of a note, but that it may not be valid.
That's
Is that
right.
the argument? Okay.
That's
So how is
on
that
the
going
third issue.
to, how is that going to standing?
The first case was dismissed
No, this case. How's that going to
If they
standing?
can't produce the original note under UCC, specifically...
No, but why isn't that just, if you went to trial, a question that you are trying to resolve at trial, if you went to trial? I'm not really clear how that's about standing.
Because to get standing, you have to, under Aurora Loan Services versus Taylor, case I'm very familiar with,
Yes.
you must have the original note. If they don't
Okay.
have the original note,
Right,
they can't
and they
get
put in
standing.
evidence to show that they're in possession of the original note at the time that they commenced the action, right?
But then,
And your point, as other members of the bench have already said, is, well, we just want to see the original. The
That's
copy's
right.
not good enough, the rest of it isn't good enough.
How
But
do we
again,
know
your
it's not
point, as
fraud?
I understand it, your point is not that they don't have the original note.
No,
Your point is that whatever document they have is invalid, because it's forged or whatever it is you're arguing.
before the first case was, or when the first case was started, I got a call from Margie, Secretary Flower Medley Markowitz, who since passed away, okay, who specifically told me that the closing ceremony, there was 3 people in attendance, Ms. Caliguri, Brandy Medley from Flower Medley, who's now institutionalized, and also the towel closer.
Well, but we
Margie
have
told
rules,
me,
Counselor, we have rules of evidence that allow a foundation to be laid about business records and so on and so forth. So it doesn't require the affidavit of someone who was physically present at the closing, does
no,
it?
I agree with you.
Okay.
But let me tell you, Margie told me, she called me
Wait,
and told me,
is this in the record?
no.
Okay, well then,
So look, if the affidavit in Aurora was sufficient, why is this not?
Okay, the affidavit in the Rory, this honorable court specifically said that there was no demand for the production of the original note, but inferred that if there was a demand, it had to be produced.
So
That
are you,
was the
I'm sorry, are you
inference.
arguing for a per se rule that every time the original note is demanded in discovery, you have to produce it before you can get summary judgment? Is that the rule you want?
Yes, especially since Judge Baisley specifically ordered that be produced, and they never produced it. So on that issue, there's collateral estoppel.
But even if there's nothing that they present that suggests that they don't have the note, but rather all of their evidence suggests they actually do have the note, and in this case, Mr. Caliguri doesn't come forward with anything to suggest they don't have the note. All he's saying is whatever you have is not valid.
However, how did they get by the fact that Judge Baisley, in the first case, specifically compelled them to produce the
Well,
note?
isn't the reason that this is a negotiable instrument so that there is not really...
Absolutely.
So that there's not really a collateral estoppel effect because the bearer of the owner of the instrument can negotiate it, right?
Yeah,
That
but
is to say,
in
the
this-
bank could have sold it to me, and I'm not going to be collaterally estopped by Judge Baisley, am I?
Except I disagree with you.
Okay.
The first case was started by J.P. Morgan Chase. That's the same plaintiff in the second case. So why are they not bound by the...
So your view is they could have, your view is the Chase could have sold me the note, and I wouldn't be barred.
That may be different, but the
Well,
fact
that's what
that
I'm
it was
asking
the
you to
same
answer.
plaintiff...
Is it different, or is it maybe different?
No, I think if it's a different, if it's an assignee of the note, that may be different. Okay, but when it's the same plaintiff in,
but what if this same plaintiff actually didn't have the note when the first action was brought, but now does have the note? Why would that same plaintiff be precluded from commencing the action now that it has the note?
why? Because then why did they commence the first action when that was part of the cause of action? If they didn't have the note at the commencement of the first action, they should have commenced the first action.
Right, and they got
thus-
dismissed. They
Excuse me?
suffered a consequence.
That's right.
Right, but to Judge Stein's point, now they've got the note.
How do we know? We never saw it.
They presented a copy, and they've got other evidence that suggests the chain is intact.
If you look at that.
And your client is not saying anything that puts it in question.
Except that we did at the
Other
first.
than saying, look, when we asked for it before, they never gave it to us, but that's not a
We
reason to
actually
put it in
asked for it in the
question.
second case, and they never produced it. Instead of producing it, they merely filed the motion for summary judgment before the time limit for the production.
Well, did you raise a 3212F objection?
Absolutely, Your Honor. Absolutely.
Where in the record did you raise a 3212F objection?
In the first motion for summary judgment.
You raised that provision of the CPLR?
Yes, I do.
Thank you, counsel. Let's hear
Thank
from
you.
respondent.
Certainly, Your Honor. Alan Schoenfeld for JP Morgan Chase. Judge Wilson, to start with your question, I think this case is directly controlled by Aurora Loan Services. There, the quote, critical issue was whether the record demonstrated a basis for finding that Aurora had standing to commence the mortgage foreclosure action. The same question is presented here, and as an Aurora loan, the answer is yes. There is here the plaintiff demonstrated its standing by attaching a copy of the note to the complaint and submitting an affidavit by a knowledgeable person describing.
But he does
the
have a
bank's-
point when he says this argument about producing the original note. The court in Aurora didn't say that that's irrelevant, and it could have done so.
Well,
By
so.
saying you didn't raise it, you're leaving the possibility in the question open. So why didn't you produce the note? Is it burdensome? What's the
I
story?
do think it's burdensome, and I think it's an important point to raise. So in a world of negotiable instruments where possession is the linchpin of your rights, transporting notes all across the country from a secure facility in Monroe, Louisiana, where there's no issue as to the authenticity or the possession of the loan, is burdensome. It will create much more litigation.
So how does the defendant put that authenticity in question without inspection?
So I think, I mean, his position is that it's not his signature on the loan. He's the one who would know if it's his signature on the loan. In years of litigating this case and litigating an authenticity defense, he has never once submitted a verified answer or a sworn declaration saying that is not my signature on the loan.
So you're saying his argument is one that is based solely on his own knowledge, in that sense?
Yeah,
That
absolutely.
Seeing
With
the original note is not going to change that?
With respect to authenticity, absolutely. There's a notarized document in the record, the consolidated note, that says that it was physically signed and it was signed in the presence of a
Is
notary.
there any affiant who says, I saw that original note?
I'm sorry, say it one more
Is there
time.
any affiant who swears under oath, I saw the original note?
So I think the notary who notarized the SEMA is notarizing a document that waives any objections to the authenticity of the original note and consolidates them under a consolidated agreement. So Mr. Caliguri, in executing the notarized SEMA, I think waived any objection that
But
the
with
origi-
respect to the affidavit in support of
with
the summary
respect to the
judgment,
affidavit that was submitted.
your employees, let's put it
Yeah,
that
the
way.
affidavit of note possession. So Sherry Stafford submitted an affidavit saying, in her role as a custodian of the
Did she ever
record,
see the original note?
she does not testify that she saw the original
Okay.
note. That's a hearsay objection that Mr.
Okay.
Caliguri has never made.
All right.
If he wanted to contest the adequacy of the Stafford affidavit of note possession on that ground, he was certainly free to do so in the trial court, but he never did.
So before the litigation started, over here,
I'm sorry,
Before
thank
the
you.
before the litigation started at all, there's a default essentially, and Chase sends a notice of default, wouldn't Mr. Caliguri have had the ability under UCC 35051A to demand production of the original?
I don't know the answer to that question.
Do you know whether he ever tried?
I don't believe in the non-litigation posture he ever demanded production of the original note. He paid on the consolidated note between 2007 and 2008. He defaulted in September of 2008, and foreclosure proceedings began, I think, about a year later. I'm not aware, I can't say one way or the other, whether he ever demanded production of the note in a non-litigation posture. And of course, everyone knows about the first foreclosure proceedings. But in the second foreclosure proceedings, the documentary and testimonial evidence before the court was identical, if not superior, to what was before the court in Aurora Loan Services.
So let me be clear here. No one's ever come in and said, we have the original note, I've seen it, and here's my affidavit, I saw it, so the copy's valid, right?
Correct.
Okay. So we have a split now between the third and the fourth department and the first and the second department as to what amount of proof would be required to establish possession of the original note. Where would you fall on either side of that split?
So I think the issue was waived in this case. I want to answer your question, but the issue is waived
It's all
because
right.
that's a
Go ahead.
hearsay objection. I agree that there's a split below in cases where the issue is properly preserved. It's also not necessary to address the question in this case because
So
JP Morgan.
leaving that aside, where do you fall on either side of that? You?
So I don't think the Stafford affidavit testifies to her inspection of the physical note.
I understand that. Where do you fall on either side of the, you have different objections there. Where do you fall on either side of the split between the departments? Because it seems that we have the third and the fourth saying, the third saying we require an individual swearing that they had to possession of the original note following review of the admissible bank records and a copy of the note being attached to the affidavit. That seems to be what the third and the fourth are requiring. The second makes reference to it, it may be a better practice, but only seems to be requiring a copy of the note itself. Where do you fall on that divide?
So I don't mean to be difficult. Are you asking what I think the rule should be? Or so
Yeah.
I think it is consistent with this court's summary judgment and evidentiary rulings that a copy of a note is a rebuttable piece of evidence about possession of the note.
So you're saying that you don't think, as a matter of basic proof, that an affidavit establishing the chain of custody or the basis for that copy is required?
So I think the affidavit does establish the chain of custody. It gives the
So
precise.
should it be required or not?
I apologize. What's it there? Physical inspection of the note?
No. Should the affidavit be required and say, I saw the note, I saw the original, here's a copy of it? That seems straightforward.
Yeah, I don't think that's required. I think the Stafford
Well,
affidavit.
how is that not required under 3212B?
Because I think
It
that.
says, the affidavit shall be by a person having knowledge of the facts. If you have no knowledge of the facts, if you can't say the copy is indeed an accurate representation of the original, how can you be a proper affiant?
So I
Because
think
isn't the question your burden?
So I think the Stafford affidavit does do exactly that. She testifies that she is an employee with knowledge of the ordinary business practice of Chase Custodial Services.
But
that
if she never saw the original, how can she say the copy is an accurate representation of the original?
Because she knows how the business records are
Well, she
maintained.
can say that's what we usually do, but she can't say that this document is indeed accurate.
I think that the evidence that she offered is enough to demonstrate the ordinary way in which
But
these
do you
documents.
agree that it's not then a hearsay objection, that it has to be that we would have to agree that under 3212B, what you have just described satisfies the requirement of admissible proof in terms of an affidavit, that the person having knowledge of the facts?
So I think she has knowledge of the facts that she testified to. I think the question of whether she needed to inspect the physical note or the business records maintained in the ordinary course that revealed the presence of the note in the physical custody of JP Morgan Chase is more than
Yeah, but the
sufficient.
problem is she's not saying that this copy is that document that we have possession of.
What she's
I
saying
agree
is
with you that she is saying we have possession of something,
Well, so-
and this is how we maintain that document.
understood, but I do think there are two distinct issues there. One is testimony that JP Morgan Chase is the physical custodian of the note.
Okay.
It's a separate question about whether the copy of the note is in fact a copy of the original. I think you can separate those two things out. Sherry Stafford's affidavit is an affidavit of note possession. She is testifying to the circumstances under which JP Morgan Chase came into possession of the note for purposes.
So then you think if you hadn't attached, doesn't that then lead to this conclusion, that even if you didn't attach a copy of the note, it would have been good enough? Because she has said in her affidavit, this is the way we do our business, and this shows we have possession of the note. I don't need to show it to you. I'm telling you we have possession of it.
I do. I think either of those pieces of evidence, probably standing alone, would be sufficient. Together, they are incontrovertible, and certainly haven't been
You
controverted by
mean
Mr.
without the
Caliguri.
affidavit, just a copy of the note would be
So
enough?
that's certainly the rule in the second department, or at least as some courts have articulated it, is that submitting a copy gives rise to a rebuttable presumption that you are in possession of the note. But again, there are two reasons why I don't think this issue is squarely presented for the court. The first is JP Morgan Chase established its right to foreclose as an assignee of the note from Washington Mutual, both at the time of the purchase and assumption agreement in 2008 and upon the recordation of the mortgage in 2009. So its physical possession of the note is not necessary to establish its standing. So I don't think this issue, which I grant you is a complicated one, is squarely presented in this case, both because the hearsay objections weren't made and because it's not necessary to the resolution of the case. If the court were to
But as I
resolve...
was saying before, may not need to have objected. You've got to satisfy your burden. Remember, he need not do anything if you don't meet your burden.
I understand that. I think the manner in which JP Morgan Chase met its burden here, however, was a combination of attaching a physical copy of the note, which gives rise to a presumption that you are in possession of it, an affidavit that attests to the circumstances under which you came into possession of the note. Again, this is exactly what the court considered in the record in Aurora Loan Services only 5 years ago in a materially identical case, also brought by Mr. Caliguri's counsel, that presented the question of whether that body of evidence is sufficient.
And then the proof of default, and I assume the last part of your statement, because I know you're going to run out of time in a moment, is that he never rebutted the presumption.
He never
with respect to the copy.
Certainly, he never rebutted the presumption, and also with respect to affirmative defenses about ownership or authenticity.
So if he had rebutted the presumption, how would you have had to respond?
So I think there are different ways to rebut the presumption. It depends on whether he's talking about
No, forget
authenticity.
about it. Let's just assume he did. He said, "Oh, there's a question of fact here, blah, blah, blah." How would you have had to respond? What would your burden have been then?
So I think it's possible that we either could have brought in another affidavit that said, I physically inspected the note as further proof, or we could have produced the physical note. But again,
Right.
that's, you know,
No,
litigants-
I'm thinking beyond your case.
Absolutely.
You understand? Okay.
I do
And
understand.
if you didn't, then you haven't met your burden, and you're going to trial? Or he
Say
could
that one more
cross-
time?
If you didn't, you haven't met your burden, you can try and cross-move for summary judgment, but let's say he didn't, then you're going to trial, and you have to
Exact-
decide what to do with that.
Yeah, exactly. I mean, the ordinary rules of summary judgment apply in mortgage foreclosure cases. We had a right to move when we did with the proof that we had. It met our prima facie burden. We also disproved all of his affirmative defenses. It stayed discovery, including production of the note. He could have moved under 3212F. I don't believe he did. I don't believe he raised it until his reply brief in this case. The court made clear that he didn't object to the sort of procedural choreography that eventuated in the motion for summary judgment, the Supreme Court below. And so I think all of these issues may present thorny questions in other cases, but they're not presented here.
Thank you, counsel. Mr. Hertzberg, you have your 3 minutes of rebuttal, sir.
Thank you. First of all, counsel's absolutely incorrect about the effect of WAMU or Washington Mutual transferring the note to, if they actually transferred to Chase. Under 12 U.S.C. 1823 and the U.S. Supreme Court case called Dench-Dumey, the only thing that is knocked out from a defense is any side or secret agreements. This is not a side or secret agreements. Okay? This is actual physical production of a note. That's not a side or secret agreement. Second of all, he talks
What
about...
about his argument that really only a response to this question of the copy versus the original is that it's forged? But Mr. Caliguri has never said, I never signed such a thing.
Mr. Caliguri cannot say that that's the note he actually signed. Let me go on.
Oh, I see.
He talks about this, the Stafford affidavit. Paragraph 4 says, according to Chase's custodial system of records, M Trust, Chase received the original note on 9/19/2012. 5, Chase maintains possession of the note at its storage facility located at 780 Delta Drive, Monroe, Louisiana, 71201. Second, first of all, they never produced a business record to show that Chase still maintained the business record. Also, the first action was started in 2009. What happened if Chase got possession of the note in 2012, but the first action was commenced in 2009? What happened to the interlude? Where was the note? This note, I don't think, is the original note. And we've been trying to prove it. Second of all, if the note was actually in a storage facility in Monroe, Louisiana, how difficult is it for the production of the original note? All they had to do was send it to council. When Judge Baisley issued the order, he specifically said that the plaintiff's counsel, Chase's counsel, take physical possession of the note and let the inspection take place. We went there, Mr. Caliguri, myself, and Mr. Lauber. They admitted that they didn't have the original note. Did this note that they attached as a copy magically appeared? Where was it from 2009 to 2012?
Thank you, counsel.
Thank you.